In today's video, I'm going to take a look at buying and selling a business in Ireland. So it's going to be an overview. Now, I've had a lot of people coming to me in the last number of years who at various times have bought some sort of a business, perhaps a small business. And sometimes they come to me too late. Sometimes they come to me after the fact. Many times they don't carry out their due diligence. They don't carry out necessary sort of checks and balances beforehand, and it can lead to appalling mistakes. And the naivety and the innocence is quite frankly amateurish. And for somebody to go along and sign a lease or sign a contract to buy a business and then buy a business and then turn around 6 months later or 6 weeks later when a dispute has arisen and they are talking about what somebody said to them on such and such an occasion, or what the landlord might have said, or what the vendor might have said, it really doesn't make any difference. What's in the contract or what's in the lease is the most important thing. So not doing your due diligence, not getting professional advice at the outset is a big mistake, and it's one that I see the consequences of very, very frequently. Hopefully you won't make that mistake if you're thinking about buying a business, or indeed if you're thinking about selling a business. But if you're selling a business, you're more likely to be experienced, you're more likely to have gone through some sort of experience in terms of running a business, buying a business, and so on and so forth. And you probably by this stage have recognized the value of having professional advice and taking the thing seriously. If you're buying a business though for the first time especially, there is a danger that you're going to be so wound up with the excitement and with the ambition that you may overlook very, very fundamental things. So let's take a look. Two methods essentially of carrying out the transaction of purchasing a business. One is a share purchase and the other is a purchase of the individual assets and liabilities of the business. A share purchase means that you're buying the shares of the company. So a company may well be carrying on the business, you're buying the shares, and so you buy the whole shooting match. So the company owns the shares, the company owns the liabilities, and you're buying the company. So you're buying 100% of the shares, and that's it. You take on whatever the company has with its warts and all. On the other hand, you may not be buying a company, you may be buying just the assets and liabilities of a business. So somebody may be carrying on a business as, say, a convenience store or a central supermarket or a coffee shop, and they may have a limited company. You may not be buying that limited company. You may be buying the assets, the shop, the lease, the freehold, the stock, the equipment, and so on. And you may be setting up your own company, or you may be carrying on as a sole trader or a partner, but you're not buying the company, you're buying the individual assets and liabilities of the business. That second part then, the purchase of the assets approach, not buying the company. So you pick and choose essentially which assets you purchase. If you're buying a coffee shop, for example, you might say, okay, I'm going to take the lease and I'm going to take that equipment, but I'm not taking those tables and chairs because they're absolutely rubbish, or whatever. So there may be an element of negotiation. There may be an element of picking and choosing assets, and the vendor then obviously will try to get rid of everything to you, but you need to try to negotiate. So there is an element of being able to pick and choose. You also will be able to choose to a certain extent what liabilities you will assume. So if there's any liabilities from the previous business operator, then you would be trying to circumscribe those in such a way that those liabilities do not fall on you, that they actually go with the existing vendor. The disadvantages of buying assets, liabilities: there's no tax benefit of taking over the existing business. So if you take on a limited company, you buy the limited company, you buy the shares, and that limited company has accumulated losses of say 50 grand built up. Well then, going forward, if you buy the company, then you can use those accumulated losses in against future profits that may arise in the business. So that's a tax advantage. You won't have that if you're buying individual assets and liabilities. There's variable stamp duty rates then applicable if you're buying the individual assets and liabilities. So you're not buying liabilities. So when I say variable stamp duty, I mean, for example, second-hand equipment will have a different stamp duty rate than commercial property. So if you're buying a freehold premises, or if you're buying a leasehold premises, you're buying a lease on a coffee shop, then you're going to be paying 6% because it's a commercial property. On the other hand, you're looking at buying some second-hand equipment and some stock, and again the stock will vary depending on the stamp duty rate applicable and so on. Whereas in an asset purchase where you buy the limited company, you pay 1% on the assets, the shares rather, you pay 1% stamp duty on the share purchase. So stamp duty on a share purchase is only 1%, and you may have the benefit of being able to benefit from any tax losses in the company, the target company that you're taking over. Both scenarios will almost certainly include a transfer of undertaking, that is, 2P regulations will apply. So regardless of whether you're taking over an existing business by way of a share purchase or by buying individual assets and taking on individual liabilities, you're probably looking at transfer of undertaking regulations applying. In other words, existing staff, their contracts, their terms and conditions will transfer from the vendor to you on the takeover of the business. Due diligence is vital before you purchase. Due diligence would look at things like insurance, legal, is there any pending claims against the business, accounting, environmental, is there any threatened prosecutions, for example, from the local authority about the discharge of waste, say a petrol station, say a leaking tank, say a coffee shop or a chip shop or whatever, discharging grease into the sewer, etc. There may well be environmental prosecutions pending, so these are the things you need to look at. Also, there's statutory obligations. Statutory obligations would include the obligation to file annual returns. If you buy a limited company and then you discover that no annual returns have been filed for a number of years, then you're looking at a big problem from the company's registration office, who will be looking for you to make returns and or will prosecute you in court for failing to do so. Due diligence is absolutely essential in relation to title. Title is the legal title to the property, if it's a lease or a freehold or whatever. That's absolutely vital. Again, another aspect of title would be planning. It's essential that the due diligence is carried out there. Taxation is another issue. To say if there's accumulated losses, well and good, but if you buy a company and there was outstanding liabilities to taxman or outstanding VAT or something, it's quite possible that the VAT is going to end up with you if you buy the company, the VAT liability rather. That is something that you need to be careful about. This list of items to do with regarding due diligence is not an exhaustive list. That's why you need to get advice, accounting advice and legal advice. Warranties then are statements given by the vendor to the buyer in relation to the business being acquired. So the vendor will give some sort of a formal statement, a warranty about the business or about some aspect of the business. So warranties would normally cover matters such as the target company's accounts, pending litigation, taxation, employees, assets, liabilities, and essentially all aspects of the company's affairs. For example, what is the situation in relation to pending litigation? If you buy the company and there's pending litigation or litigation in being against the company, are you aware of that? You may not be. You're looking for a warranty from the vendor to say that there is no litigation in being, certainly. Also, employees. Is there any claims to the WRC or the Labour Court coming from employees or threatened by employees? Again, you'd want to look for a warranty in relation to that. You'd also want to look for information about employees' contracts, because there's no point going into a place and discovering after a while that the employees have gold-plated contracts with really, really good wages built into them. If they have, you can't really change that. They have an existing contract of employment, transfer of undertakings regulations apply, they transfer over and they are golden. You need to find this out beforehand though. There's no point finding out afterwards and then coming to a solicitor, a fellow like me, or a lady solicitor or whoever, and discovering that there's absolutely nothing you can do about it and you're bound by the contract and the employee knows full well that they are protected. Another aspect of it is a disclosure letter. This is a letter from the vendor to the purchaser, you, which sets out where the target company has any issues in relation to the general warranties already provided. So it's a disclosure letter. It's basically saying, look, there is circuit court proceedings instituted against the company or against the business for X, Y, or Z. You need to know this. The disclosure letter, as I say, may disclose any problems the target company or business has in relation to employees, title to the property, insurance, banking facilities, and any number of areas where the actual position on the ground deviates from the warranties given in the agreement to sell. The disclosure letter, as you can imagine, is supposed to disclose, and it's a whole body of case law arising from what is or should be disclosed and what was or wasn't disclosed. Now, our thing is stuck. Yeah, look, if you have any issues, what I would strongly recommend is, or if you're contemplating buying a business, you really should get legal advice. There's no point going to a solicitor or an accountant after the fact and discovering that you have an absolute haymaker of a potential liability or a problem. Hope you find this video useful. If you do, give it the thumbs up down below. And my experience in buying and selling businesses is a fairly long one. I bought my first business in 1986 at the age of 23. I've bought and sold quite a few since then, and I know my way around this stuff fairly well. Hope you find the video useful, and if you do, as I say, give it the thumbs up down below, and you may be interested in subscribing to my YouTube channel.